Immigration lawyer. Today I'm going to cover the questions in the comments on the YouTube channel. If anyone is joining live, they can ask their questions. I'll try to answer them. He did not start his employment. He did not start his employment for up to 3 months, and after 3 months he started. So it's more. I don't think it will affect your extension application. As of today, whatever the rules are, I can only tell you as per the current rules. It will not affect your extension application. The change in the work start date is more of a compliance matter for the employer. They have to report through the sponsor management system any changes in the work start date, and that should be reported to home office. But whether or not your employer has reported, it doesn't affect you per se. It will not affect your extension. So the next question is from Habibur. Currently, I'm doing my master's course. My course will end on 30th of June. Class already end. How many days before the end of the course I can apply for skilled worker visa? Okay, the question is so you are on a student visa, and your course end date is 30th of June 2024. That is next year. How many days before the end of your course you can apply for the skilled worker visa? So how soon you can apply for the skilled worker visa? So as per the rules, as everyone is aware, the work start date of the skilled worker visa. Yeah, so there are some disturbances in the internet. I'm trying to sort out my internet here. I'm not in the UK currently, so yeah, internet is an issue over here. Yeah, I think it is fine now. So yeah, the question is, you are a student, your course end date is 30th of June 2024. How many days in advance before that can you apply? You can apply for the skilled worker visa. Ideally, if I calculate, the earliest start date of work can be 1st of July. It cannot be before that because the course end is 30th of June. So I can count backwards 3 months before that. So we can apply within 3 months because a certificate of sponsorship can only be valid for use for up to 3 months. So sometime, if I say July, so it would be April, May, June. So sometime around the first week of April is the earliest you can apply if that course is assigned to you then, because the course is valid for 3 months. And yeah, so maybe within the 3 months of the start date of your work. That's your answer. Next question from Rajitha Nair. From when is the IHS going to increase for graduate route visa? Is it fixed or 16 Jan or is it yet to be declared? Yeah, IHS, whether for graduate route visa or any other visa, IHS increase, the earliest it will happen is on 16th of January, or let's say if the order is passed on 20th of January for, or say 17th of January, it's 10 days after that order. That's how I understand the rules. So the earliest date is 16 January, but I don't think it is going to be 16 January. But so just for safety purposes, 16 January is the date that we are taking for all calculation purposes. So Abhishek, live question from Abhishek. So if I get the skilled worker visa in February after the spring, can I bring my dependent or current dependent rules? Yeah, so the dependent rules will matter on the date of application. So if you are, let's say, I'll explain it with an date example. So if the rules change on 1st of April, and from 1st of April onwards, you cannot bring dependents. I'm assuming you're talking of you are the main applicant is on a care worker visa or senior care visa, and you're not allowed to bring in dependents as per the new rules, which will come in future. So they have not been made yet, they have not been published yet. They have just been given in the news by the ministers and everyone else. So as soon as the rules become live, I'm assuming, let's say, for example purposes, 1st of April the rules go live. If you make an application on 31st of March for the dependent, I don't care about your application, your main applicant can go anytime before that. But if your dependent, your wife, your partner is applying on 31st of March, then you come under the current rules and you can sponsor the partner. But if on 1st of April the rules change and you're filing the application on 1st of April or thereafter, then the new rules will apply to you. So you may not be able to bring. So I'm on a chef work visa. So you're on a skilled worker visa as a chef. So exactly. So you already have a skilled worker visa. And exactly what I said, if let's say the rules change on 1st of April, then and you apply on or after 1st of April, you may not be, I don't think chef visa should be affected because whatever is being said by the ministers, they are mainly talking of care worker visas and senior care worker visas holders, they have not talked about anything across the board for skilled worker visas. So I'm not even sure whether it will impact you. So there is no discussion of changing the whole skilled worker rules, and no one under the skilled worker can bring independence. I don't think so. That is what has been discussed. So I don't think you will be impacted at all. Okay, next question that I have, Andy. I left my full-time part-time job that cannot okay, cannot stay in higher pay salary because it's been of 7 hours. I had to survive 60 hours of pay slip. Okay, so Andy Morley, I think you are asking for the spouse visa financial requirement. So I'm taking an example of, let's say if you only have one pay slip, you're changing from part-time to full-time. Okay, so I'll just tell you, it's very specified evidence. I don't think you will meet the requirements, but from what you have stated, I can understand that. Yeah, but then I'll just try an example and state it. So let's say if the financial requirement in your case is 18,600, and looking at your numbers, so you have a 7.5 hours a week contract, then you're working 60 hours, which you are a week that the store manager is going to confirm. I'm pretty sure you'll go under the category B, which is the variable hours, variable pay, etc. It will not be under the category A. So for your purposes, you will need at least 6 months of income. So if you are paid monthly, you will need six pay slips, those payments being made into your bank account, bank statement showing that, and the letter from the employer. And you should have already earned 18,600 divided by 2. So at least 9,300 over the 6 month period, gross amount before tax. So if you are earning monthly salary. If you are earning a weekly salary, which means you are getting a weekly pay slip and weekly payments are being credited to your bank account, however you are paid, then you would need at least 52 is the yearly weeks, 52 divided by 2, 26 weeks. So you'll need minimum of 26 pay slips, and only after that you will be able to apply. I'm assuming you don't have a previous job because you've not talked about any previous employments in your case. So I'm assuming this is the only job you have. Before that you were not employed for whatever reason. So because I don't have that information from you, you left your full-time job to start the part-time job. So I'm not sure, you haven't given me the full facts, but the way the category B works is you should have already earned 18,600 if you are taking a whole of 12 months of salary. Or yeah, so usually please speak to an immigration lawyer. It is slightly complicated in your case. But then, yeah, I don't have all the facts, so it's difficult for me to advise exactly. But then with one payslip, you cannot apply. Uh, if you have 11 months of previous job payslip and you have current payslip, you may be able to apply. But the numbers of 18,600 and all have to match up. That's very, very important. So yeah, maybe speak to an immigration lawyer. That would be much better because it looks slightly complex to me. You are changing from full-time to part-time, etc. So live question, John Marvani, for UK spouse visa, with specific evidence do the 28 days limit apply? So I'll take the example. It applies to if you are using the salary as the financial requirement, you're meeting by salary. Your pay slips, the latest pay slip should be dated within 28 days. Number one, your latest bank statement or the latest part of the bank statement should be dated within 28 days. And the letter from the current employer should be dated within 28 days. These are the three things for salary employment. So, next, Abhishek. So, my cash will finish on 31st of January. My sponsor is providing me costs from 2nd February. Okay, but I will get a result in April and my completion of program is 31st of January. I have a visa. Yes, you can apply as per the immigration rules. I'm saying yes, you can apply for your course finishes on 31st of January. So we are already on 29 December. Yes, if your employer is assigning your course even today and the work start date is 1st February or thereafter, then you should be fine. You can apply for the skilled worker visa even now. This is straight from the rules. Yeah, I'm not adding anything to that. That is has been provided in the immigration rules. If your work start date is after your course end date, you can apply for the skilled worker visa. So next question on the comments. For skilled worker visa from outside UK, do I need to submit health surcharge first before cost? Metric where I submit myself in any case, my employer. Okay, so these all the questions about entry clearance application, outside UK application. for a skilled worker visa, you are asking the order of the payment of the fees, the assignment of the costs, etc. etc. Okay, so I'll try to explain as much as I can. Do I need to submit health surcharge? So no, the first step is your employer has to assign you the cost and give you the cost reference number, whatever it starts with, usually with a C. So once you have that reference number, you fill up, or you can also fill up the skilled worker application first and then put that number on that application. That is how a complete application is made. Then you file that application. At the time of filing, you pay the immigration health surcharge first. I don't care who pays it. You can log in and pay, your lawyer can log in and pay, employer's lawyer can log in and pay, or the employer can log in and do it. It doesn't matter who does it. It's an online application form. So the skilled worker application payment submission can be done by anyone. Yeah, so do I need to submit the health surcharge first before the cost? No, you don't have to pay the health surcharge before the costs or the biometrics. Yes, you have to do it before the biometrics, but not before the cost. So could I submit myself? Yes, you can submit the skilled worker application yourself. My employer is doing my case and my family case. So your employer can do your and your family's case, or you can do your and your family's case. That is fine. It's just a matter of logging into the system and preparing and submitting the application. So I'll continue with the steps as I was saying. Skilled worker entry clearance application. Employer assigns you the defined certificate of sponsorship, gives you the reference number. You fill up the skilled worker application and put the reference number on that application. You fill up the dependents applications and put your reference number on the dependents applications. And then that's when the applications are ready. I'll take the live question, but I'll answer this one first. Then you first pay the immigration health surcharge, then you pay the application fees. After that, you book your biometrics appointment, attend the biometrics appointment. As soon as you attend, all the steps in the application process are completed. After that, it is for home office to make a decision on the application or do any investigations from that point forward. So those are the steps for you. uh, Live question. Okay, so Joseph, please, if your current employer can't provide costs after your contract, what advice can you give to person skilled worker visa 3 years ends? Yeah, this is a common problem that usually employers are not willing to sponsor. They may not have, they don't want to continue the job role, whatever other reasons. There may be many reasons. You will have to look for another employer. That is the only option. Or if you have any other options, I'm not sure what your case is. If you have any human rights applications, you have a partner who is British, settled, or something, anything else. Other than that, there are not much options in the UK. Yeah, you may have to find an employer. That would be the only main option that you can consider. If your sponsor is not willing to extend your sponsorship, if your visa is ending and they are not giving you a new cost, sorry. So that is the only option. So Abhishek Mathur, next question, but my employee asking, yeah, either result or course completion certificate, but I'll get my result in May. Yeah, your employer is asking for all these things, but I don't know why they're asking. I can only advise you as per the immigration rules. If your employer is asking for extra things, that is between you and the employer. I may not be able to advise you on that. I can only tell you what is in the immigration rules. Maybe you should have a joint consultation with your employer and immigration lawyer and yourselves and take an advice. We do that many times. Many times the employer and the employee both are on the call. We answer both of their questions. So speak to an immigration lawyer and book a consultation with them so that they get a confirmation from a lawyer. That's what my advice will be. Next question, Young. I've applied for my cause and it's been 3 months, nothing from the sponsor. You applied for the cause and nothing from the sponsor. He keeps complaining the home office has reduced the rate to issue cause, don't have the employment letter yet, no interviews yet. Yeah, I'm not sure what you mean. You applied for the cause. I think the employer applies for the cause. Uh, I'm not sure. Can you clarify that? The employer applies, and yes, there is some delay. D cost, defined cost, if you're applying from outside the UK, are taking up to 2 weeks or so. I did get some last week. I've applied some. They are in process. Yeah, 2 weeks for defined cost if you're applying outside UK. Inside UK, if they are applying, I think, are you inside UK? Let's say, let me assume you are inside the UK and the employer is applied for a cost if they don't have the allocation. It takes 18 weeks for a decision, or they can prioritize it by paying £200 of home office fees. and trying to get the slot. There are only 60 slots to prioritize per day. It's quite a difficult one. Usually lawyers get it. If your employer doesn't have any lawyer, legal support representative, maybe ask them to speak to a lawyer, or you both can work together and try to get it. But then, yeah, these are the services that are available. We do get allocations and all within a week, 10 days or so. So if you are in country, usually 5 to 10 days with the priority service by paying 200 is possible. And even if you are applying outside UK for a DCOS, up to 2 weeks, Home Office did confirm in the last week's call that we had with the Immigration Lawyers Association. It's about you are outside the UK. So defined costs usually about 2 weeks or so. I'm not sure. Are you applying for a healthcare visa or something? Those ones are taking a lot of time. I know Home Office is not approving them. They are investigating a lot. So just let me know what type of employment you are applying for. Abhishek Mathur, course employer. Yes, yeah, I answered that one for Abhishek. Okay, Emmanuel. I didn't start working with my employer 3 months after arriving in the UK. I'm on 3 years skilled worker visa. Yeah, I've answered this during the live, but still I will give you a quick answer. It will not affect. I have answered in detail in the opening of this live. Once this is recorded, you can watch it. That's the first question I've answered. So it will not affect, just to summarize the answer. So next question. Okay, Meera Bharat. So any update on the UK and professional visa 2024? So yeah, you are asking about the youth mobility visa, which is recently started for India. Yeah, there is no update yet. I think around January also they may give some update. Just keep on looking on the youth mobility page and you should get an update usually. It's not a very much looked after visa. Lawyers are not even looking at that much. The numbers are very less for India as well. But then just keep a tab and look at the web page of Youth Mobility Visa Weekly. Then you should be fine. No information yet on the Youth Mobility Visa ballot for Indian citizens. Okay. I'm applying skilled worker visa. So, Yang, what is your job role? If you tell me the job role, it will help me. I know it is a skilled worker visa. So, next on the comments, what are the necessary things to include in a legal compliant offer letter to hire a full-time skilled worker visa as an employee? Okay, the question is about, so what you're asking is what are the necessary things to be included in a legally compliant offer letter to hire a full-time skilled worker as an employee in the UK? Yeah, I will not be able to advise on employment law matters. Speak to an employment lawyer for that. You're talking of an legally compliant offer letter or employment contract. Yeah, I don't, I will not be able to advise on that. I only practice immigration law. Speak to an employment lawyer. They should usually give you a draft or review the offer letter and advise you accordingly. Okay, all the questions on the comments are done. I'll take live comments. Any questions? Okay. So healthcare assistant visa, yeah. So your employer, those D courses are taking a lot of time because there is a lot of fraud going on in the system. Home office is not happy with it. They are trying to delay it also. So that is one reason I know that we lawyers were discussing that these defined courses are taking a lot of time for healthcare visas, assistants, whatever that is, senior healthcare visas and all. So yes, it may take time. They may be investigating if there is a genuine vacancy. Are they trying to sell you things, etc.? So it is possible it may be delayed, and I'm not sure how you obtain the employment and all. So, but then maybe look for another employer if you're looking for work. But those courses are taking time. I'm aware of that. So next is Emmanuel. Can a dependent with no experience work in the NHS and later get on a course? I'm not sure what you mean. So working in the NHS, I think you should speak to NHS for that. What experience they need, I'm not an expert on that side. Uh, and get a course, yeah. If NHS wants to hire someone, they can sponsor them. But then about the experience and all, you have to speak to NHS for that. I cannot advise on those matters. So, or say if someone is on a dependent visa and the main applicant course expires and they are not in a relationship, dependent visa course expires. So you mean skilled worker visa expires, they are not in a relationship anymore. What are the risks for the dependent and also what can he or she do? So your question is a dependent on a skilled worker visa And the main applicant's course expires. I don't understand what you mean by course expires. The course is no work mere consent with the visa. So if the visa, the permission to live in the UK, remain in the UK or enter the UK has ended, that is the visa has ended, the skilled worker visa or the dependent visa, do you mean that? Clarify that first. I'm not sure what you mean by course expires. Yeah. So if you are saying, I'm assuming that the main applicant's visa expires, the dependent's visa will also expire at the same time. They are not given more visa than the main applicant. What are the risks for the dependent? Yeah, the dependent also has to, so if your relationship is broken down, you need to move to some other category of visa, whatever that is. Maybe get a sponsorship for yourself, move on to the student visa, whatever the other options are. Your dependent visa will also be no longer valid if their sponsorship has ended, whatever has ended, their visa has ended, the dependence visa will also be no longer valid. I know Home Office doesn't get to the cancellation and all, that's a different matter on the procedural side. But then, yes, the dependent should also try to find their own other options of switching into another category. All the questions on the channel are done. There are no more live questions, so I will end this live for now and I will try to go live in the week. Thank you very much for whoever has joined, and this live will be saved. Thank you.